is Representative Ted Poe. Mr. Poe represents Texas 2nd District and is a member of the Judiciary and Foreign Affairs Committee. I'm glad to see you, sir. And our second witness is Representative Ken Calvert. Mr. Calvert represents California's 42nd Congressional District and is a member of the House Appropriations Committee. I'm glad you're here. And so I would now recognize our first witness, Congressman Ted Poe. And if you'll turn that microphone on, I know you'd. Yes, sir.
Thank you, Mr. Chairman. Thank you for allowing me to be here. And I want to thank the ranking member. And also, I would like to thank Congressman Calvert for his work on this issue for a good number of years. As the chairman has pointed out, has pointed out in the past, I'm a former judge, prosecutor, and lawyer, been in the legal profession for almost 40 years. And this is a situation where this particular hearing that we're having deals with, I think, abuse of a good law. I believe strongly in the ADA, and it needs to be always enforced. And the goal of the legislation is to make sure that when there is a violation anywhere across the fruited plain, that the violation gets fixed so that there is accommodation for the citizen to get into that business. But the legislation hopes to prevent what is occurring, that there are lawsuits being filed not to get accommodation for the citizen, but to get money so that people settle, and the alleged violation may or may not ever be addressed. And what happens is that lawyers are making a lot of money off of these, what I think are frivolous lawsuits, to the detriment of the person who is actually being prohibited from going into some businesses, because the goal is not being reached to allow accommodation. What is happening is lawyers are filing lawsuits, businesses settle rather than go to court, and the lawyer gets, we don't know how much of that money. So in the last 10 years, there have these frivolous lawsuits have been filed under the public accommodation section of the ADA. Some of these lawsuits are, in my opinion, shakedowns for businesses, and they're using the ADA as a basis to obtain quick settlements rather than go to court. For example, some of these law firms, and there are specific law firms in different parts of the country that do, they will file a notice or give a letter stating that there is not a proper pool lift in a particular motel or hotel. And some of these hotels don't even have a pool, or these motels. But the businesses settle rather than go to court because of the cost of litigation. And that is the motivation of these lawsuits. And we're talking about settlements of around $5,000 apiece. Often the same individuals or organizations who are making many of these claims go from business to business. And it's a business model that's been working, especially in the last 2 years, where 10,000 of these lawsuits have been filed. In Florida, a plaintiff named Howard Cohen, no relationship to the ranking member, has filed 529 of these lawsuits. California, Martin Vogel's filed 124. In Pennsylvania, Christopher Milo has filed 21 of these lawsuits. And in some cases, like Howard Cohen, he sued the Marquesa Hotel in Key West for an alleged violation of their pool, despite the fact he was never a registered guest at the hotel. Sounds somewhat suspicious. The ADA expert who actually wrote part of the ADA bill, Bill Norcus, helped the hotel fight in this particular case. And he stated that Cohen was essentially operating, quote, a continuing criminal enterprise that boils down to extortion. That does not get people into these motels. It does not accommodate these individuals. It allows for, as he said, shakedowns for money to be collected by these, as I think they are, ADA trolls. And some of the letters and notices are so nebulous that the person receiving the notice doesn't even know what the violation was. We have a realty company in Houston manages many shopping malls, and in one particular shopping mall, there's 40 parking places that are painted blue and ADA compliant, but they're still sued because the violation doesn't allege, or the letter doesn't allege what the specific violation is. So this bill will require basically three things: that they be put on notice so they can fix the problem before there's a lawsuit. If that's the goal, to fix the problem, put the business on notice. If the business doesn't respond to this notice within 60 days, lawsuit commence. If the business then doesn't fix the problem within 120 days, and I think that could be worked on how many days, file the lawsuit. That does not prohibit the citizen from filing and getting their day in court. But if we want to fix the problem, let's fix the problem. It also allows for arbitration if the sides want to arbitrate. It's not required under the law. It's voluntary, and it also requires that the Justice Department come up with some very working with the industry and the people in the ADA community, different models on how they can educate all businesses throughout the country on what the ADA says and how they can comply with the law as it is written. So that is why this legislation is. It's to put them on notice, fix the problem, get it ADA compliant. It's not to really allow for these frivolous lawsuits to be the money going to, I think, the attorneys rather than fixing the problem. And I'll yield back.